In this podcast, I want to give some quick tips for exam preparation in the copyright, for the copyright lectures that we did this year. So I just want to quickly do three things. First, quickly outline the issues that are going to be assessable on the exam. I want to provide you with a general structure and some tips for answering a practical copyright question. And I want to put those into practice by having a look at the 2012 past exam, question 2, the copyright question. We'll go through a sample answer outline together. Okay, so first, what is accessible? So the short answer is that everything we covered in the 4 weeks of copyright is accessible. Now that's a lot of material, so you'll have to think about the depth that we're going to cover, that we covered each particular subject in. So we spent most of our time on direct and indirect copyright infringement. So we spent a lot of time on subsistence of copyright, ownership, infringement, defenses, and remedies. So for both direct copyright infringement and for dealing with infringing copies, that's where you should spend the bulk of your time in revision as well. That's going to be the main focus of copyright on the exam. You do need to know the other material, but you don't need to know it in the same sort of depth. You will need to know authorization liability in broad terms, how it works. You'll need to know the Section 101 three-factor test and the basic authorities from Morehouse and IINet. And you will need to know moral rights that we spent the first half of the last week in. Then, for the other material in that last week, you probably only need to know roughly how the scheme works and be able to identify the operation of the scheme and apply that in broad terms. I don't expect you to know all of the authorities in all of those particular cases, but you will need to recognize the issues and be generally able to respond to that sort of question. So that includes anti-circumvention law, the resale royalty, performers' rights, the copyright design overlap, and a little bit of open licensing. Okay, so your main revision focus should be on the 5 parts of copyright that I'm about to talk about in relation to direct and indirect infringement and moral rights in some detail as well. So how do we approach copyright questions? I want you, every time you get a copyright question, to break it down into 5 separate parts. First, we need to look at subsistence. Where are the works and other subject matters, or which works and other subject matter are implicated in the exam question or the practical issue that you're facing, where copyright might actually subsist. So you need to know the difference, firstly, between Part 3 and Part 4 subject matter. And then you need to know the types of subject matter that's covered in each one of those parts. So for original works, it's literary, artistic, dramatic, and musical works. For the Part 4 subject matter, these are the production copyright, the broadcasting copyright, the published edition, the cinematography, the films, and the sound recordings, and so on. So you need to know the difference, obviously, between Part 3 and Part 4. Main difference, or the 2 main differences, is 1, a requirement of originality in Part 3, and a stronger protection of the reproduction right in Part 3 works, as opposed to Part 4, which only covers direct copying. And then you need to know the rules for ownership, both the default rules, the exceptions to the default rule, and obviously that ownership can be modified by contract. Infringement's a little bit more detailed. We need to know how an infringement is actually established, both a direct infringement, which is by doing one of the acts comprised in the copyright, usually by copying, reproducing, broadcasting, and so on and so on. You'll need to know all of those different acts that trigger infringement, and they differ for any given copyright work. Not for the category of work. So the acts that infringe a film are going to be different to the acts that infringe a broadcast, different to the acts that infringe a Part 3 literary work, again, different to the Part 3 musical works. So you need to be sure what those acts are, and you need to be able to find them in the legislation. Most importantly, you need to be able to identify them in the facts. You'll need to know a little bit of authorization liability, as I said, but mainly I want you to focus on direct and indirect infringement. You will also need to know the defenses to copyright, the fair dealing defenses and the other limited royalty-free exceptions and the basic outlines of the statutory licenses that exist that will excuse or limit the infringement action. And finally, you need to be able to identify the remedies that are available for copyright infringement. So there are 5 steps that I want you to take every time you come up against a copyright question. So the first one, subsistence. The questions we need to ask here are, first, is it a Part 3 or Part 4 subject matter? If it's Part 3, is the work original? Is it expressed in material form? Is it something which falls into the categories of literary, dramatic, musical, or artistic works? And does it have an Australian connection? 4 tests to determine whether or not copyright subsists. The 5th there that I didn't mention in that outline is, has it expired? And you'll have to look at the expiry term, which is different again between Part 3 and the different Part 4 works. For Part 4 works, we don't look at originality, but whether it is a sound recording, film, broadcast, or published edition that has an Australian connection. You need to then check whether any assignment has taken place or whether there's been a license that has been given. The next question is ownership. The default rule under Part 3 is that generally the first author of a work is the owner. Obviously, that's modifiable by contract. And the default rule under Part 4 is usually that the maker of the broadcast or the producer of the film or the maker of the sound recording and so on is going to be the first owner of copyright. Again, in practice, all of these are always modified by contract. Then you come to the tricky parts. After identifying all the works, you have to look at all the potential forms of infringement. And you need to go through the facts fairly carefully and make sure you don't miss potential actions of infringement. Because usually, in a particular subject matter, there'll be more than one copyright work. So, for example, if I copy a film, I might be making not only a reproduction of the Part 4 film, but the original screenplay, the musical works, the sound recordings that are embedded in the film, the dramatic works in the script, and so on and so on. So you need to be able to identify all the potential works and all of the infringements that might apply. And you'll only be able to do that through practice. Then we look at, has there been an actual infringement? Go through the infringement tests. Has there been a potential authorization infringement? So that is, if there has been a direct infringement, might it be possible that there is also someone else who is responsible for authorizing that infringement? And then finally, has there been some sort of dealing with infringing copies that constitutes indirect infringement? For example, importation or sale of infringing copies. Then we move to defenses. Check first all of the fair dealing defenses, then check the specific royalty-free exceptions, the private use exceptions, the computer software exceptions. There's a whole range of them. Incidentally, that's why the ALRC suggested we just consolidate all of those into a fair use exception, which would probably make our act a lot more simple, if not our job much more simple. But unfortunately for now, you still have to work through and identify all the potential defenses that might apply, or the exceptions that might apply to copyright infringement. Then you have to check the statutory licenses as well. Now, the statutory licenses are fantastically complicated. I'm not going to ask you to know them in a huge amount of detail, but you need to know that they exist. And finally, remedies. And the most important remedy in copyright is usually an injunction, as in other forms of IP, the ability to stop the person, to enjoin the person from infringing or continuing to infringe or attempting to infringe copyright. And then you get either damages or an account of profits at the election of the plaintiff, and there might be additional damages that apply under certain circumstances. You'll have to work through that, but it's not terribly complicated. There are also criminal offences usually for commercial scale dealings, commercial scale infringements under the Act. And then finally, you also need to know moral rights. So look particularly for the moral right of attribution, the moral right of integrity. Has the way in which the copyright material has been dealt with, does that trigger a potential cause of action under the moral rights? Okay, so let's see how that actually applies in practice. So I have here the question 2 from the 2012 exam. So you'll find this on the course materials database, but it's about Audrey, who is an advocate for refugee rights, and she makes a particular film modeled after Samuel Beckett's Waiting for Godot. So the first step, 1, subsistence. Where are the different rights that exist in this particular in this fact scenario? So as we're scanning through in perusal, I want you to make sure that you highlight everything that could be a copyright work. So Audrey's got a copyright work. She's made a film, but we're not really. It seems we're not interested in her copyright. We're looking to see whether her film infringes Beckett's copyrights. Remember to check the wording here. We are asked to advise Audrey and also to CineSpeech as to whether it may be liable for any of Audrey's acts. So first we need to look at primary infringement, and then we're going to have to look at authorization liability potentially for the entity called CineSpeech. Okay, so where are the copyright works? So there's Samuel Beckett's play, Waiting for Godot, which is going to be an original literary or dramatic work. We've got to check whether there's any other copyright interests that are potentially infringed in this particular fact scenario. And be careful, because the main one is that play, which is going to be a dramatic work, but there might be something else as well. And you'll see all the way down the bottom that in the soundtrack, Audrey uses songs from several popular Australian bands that she's converted from her home CD collection into a digital format. So there are other works, and we'll have to look at that. The first one then is a original Part 3 play, which is going to be a dramatic work. The others are recordings under the Part 4 works, Part 4 subject matter, sound recordings in the music, and there'll also be underlying original works included in that, which are either the Part 3 literary works in the lyrics and Part 3 musical works in the music that is embedded in the recordings. Okay, so that about covers us for most of the subsistence. We need to look to make sure that all of these, the copyright actually subsists in all of these works. And we can do this pretty quickly, but we need to work through the elements. So taking Beckett's play for a start, Section 32 deals with dramatic works. We say it's certainly expressed in material form. It's been written down. It is a dramatic work. A play is obviously a dramatic work. It's original in that it originates from the author. And be careful of that in relation to the ICE TV case, for example, and the new phone directories case about what original actually requires under Australian law. But this is clearly original. The problem is there's no connection with Australia. Now, it's only 1 point really in the exam, maybe half a mark in the exam, but you would have to note that Samuel Beckett is not an Australian person. Waiting for Godot was written between 1948 and 1949 in France, first performed in 1953 in Paris. Now, you'll note that both Ireland and France are signatories to the Berne Convention, which means that the principle of national treatment applies here. So even though the play is not an Australian play, it's nevertheless protected as if it were an Australian work. And the authority for that is Section 184 and Regulation 4 of the Copyright International Protection Regulations 1969. So then we just need to check the duration of copyright. Does copyright still subsist in the play? And we know that copyright lasts life plus 70 years for Part 3 original works. And so then we just need to check when Samuel Beckett passed away. And it turns out that copyright will last in this play on until 2059, 7 years from 1989. Okay, so then we look at what other works there might be, and we're just going to really quickly note that copyright also subsists in the music, the musical works under Part 3, the literary works and the lyrics under Part 3, and the sound recordings under Part 4 on the CDs that she copied. We don't know who owns these. We're going to have to assume that there's a particular owner out there that we can't really identify on our facts, but so we'll just deal with that relatively quickly. As for the Part 3 play, when we move to ownership, we know that the first author is by default the owner. So without any further facts, we can assume that Beckett would have been the owner of the play. I don't know whether he transferred ownership in that to someone else, but we can assume here on our facts that Beckett was the owner until he passed away, in which case his successors entitled will be his heirs. We will just have to assume that there are some people, the original authors of the musical works and the literary works in the music, in the recorded music, and the maker of the sound recordings who will own the copyright in the music that she copies from the CDs. We don't know who they are, but we'll assume that they're different people probably. So then we turn to infringement, which gets a little bit more complicated. So first we need to check in our Copyright Act where the different acts of infringement might occur. And looking at the acts of infringement for dramatic works, if we go to section 31, nature of copyright in original works, for dramatic works, it is an infringement to reproduce, to publish, to perform, to communicate, and to adapt. And we'll see that, sorry, here, to reproduce, to publish, to perform, to communicate, to adapt. So let's look at our particular facts and see what might have happened. If we scroll up, it looks like Audrey has drawn inspiration from Beckett's play. So it's not clear yet to what extent she has actually copied the play. Now, her play is not a direct copy, but it could still be a reproduction. And for the test for reproduction, we're going to have to look at substantial similarity. So first off, what she's done here is created a play called Waiting for Bowen that is somewhat loosely based, apparently, off Godot's play. It's a satirical critique of Australia's immigration policies with regard to refugees. So we're told that the settings, the environment are the same. We're told that none of the dialogue has actually been reproduced, and the characters are quite dissimilar, although characters themselves aren't really protected in Australia. We're told that the protagonists in Audrey's film are female, not male. I'm not sure what that tells us. And then we're told that there's one particular scene. It's described as a memorable scene where the main characters contemplate to attempt suicide but fail because their rope is too short. Audrey depicts a similar scene in her film to highlight the desperation and powerlessness of asylum seekers. Okay, so here it seems like she has copied one scene clearly from the existing, from Godot's play. From Beckett's play. Otherwise, she's also copied the look and feel, the desolate and sparse environment and the vibe. We're not sure whether that's going to be sufficient to infringe copyright, so we better work through it. So in order to do that, we first look at what's actually been taken. So here we're probably dealing with a reproduction. and we need to work out whether that material has whether a substantial part has actually been reproduced. So first thing we need to look at is whether, looking at them side by side, the two plays are objectively similar. And so we look at our authorities and we say, remember the Jaws case, Zekola suggests that maybe they are, because the look and feel, the environment, the plot of the plays might have been taken, and that might be sufficient for them to be similar enough. We have other authority. You'd need to actually, here's where your hard legal analysis comes in, because you'll need to make an argument about whether or not this is more like Zekola or maybe more like, say, Bagent and Random House, which was, if you remember, was the case about the infringement of Holy Blood, Holy Grail by Dan Brown's Da Vinci Code. And there the court said that even though they took the plot and so on, lots of factual elements and lots of events, they didn't really reproduce the literary work itself. And that's probably the better analysis here. I've written down here. It really comes down to taking the setting, which probably not enough to constitute infringement. The characters, they're certainly dissimilar. The dialogue is different. The only thing that we have that is the same is the suicide scene on our facts. So we would say that there is potential infringement of the suicide scene, of that particular scene. Is it a substantial part of the entire play? Excuse me. So the question at this point then becomes whether or not the scene taken was a substantial part of the original play. And this is determined not with a quantitative test, but with a qualitative test. Was it an important part of the play? The authority that you'll have to work through is the panel case, probably the best one at the moment. There's a couple of different authorities there too. We can think of, say, the Go-Go Mobile case that we discussed in lectures. Was enough taken that we could say that it's a substantial part of the original? On our facts, it certainly seems that what was taken was an important part. The facts describe it as a memorable scene. So you'd have to make some sort of argument as to whether or not we think that this is likely to be a substantial part of Godot's play. But the fact that it's described as a memorable scene suggests that maybe it is likely to be something that is substantial. That's always a question of fact and degree, so you need to make some sort of argument and analysis there. Then we check the other forms of infringement. We know that it's an infringement to reproduce the literary and musical works and to copy and communicate the sound recordings. Very easy to prove, very easy to show. We look at our facts here and it says that clearly Audrey has used several songs from her home CD collection. She created a copy on a USB key, so that's reproduction for the Part 3 works and copying for the Part 4 subject matter, and she put that onto the soundtrack. So there's a couple of acts of copying and reproduction there that are given. Because they're direct copies, we don't need to do any of the more difficult substantiality analysis there. Then, so you just have to name the different types of infringements. So then the question is, are there any exceptions that could apply? And the most obvious one here is going to be parody and satire. Now, we don't have a lot of authority about what parody and satire actually is in Australia, so we might need to turn to US law. Now, here's one crucial way in which Australian law differs from US law in the parody and satire exception. So remember some of the US cases we discussed, and you don't need to know these in a great amount of detail, but from those basic discussions in the lectures and the slides and the materials I've referenced, it should be enough. But say you remember the Dr. Seuss case, The Cat Not in the Hat, I'd draw a similar analogy here, that what has happened is that Audrey is not making a criticism of the original author's work. So it's not really a parody of the original work. It's a satire in that it uses the work to make a political, social point. And in the US, that's not usually permissible. In Australia, our law extends to both parody and satire. So if this is a satire, and I think there's a clear argument on the facts that it is, then that prima facie falls within the fair dealing exception. So the question then becomes, is it actually fair? And for fairness, we look at, as another question of fact in the circumstances, did Audrey take more than is reasonably necessary? Is it likely to harm the market? And so on and so on. You need to make some sort of analysis and some sort of argument about the facts at hand, more than just saying the court will look at whether it's fair or not. And try to make some analysis there. None of the other fair dealing exceptions apply. There is potentially a private copying exception when she first copied the CDs onto her computer, but not once she used it on a soundtrack for a film that she released. That no longer fits within the private copying exception. And as to whether the defense of parody, if it's established with respect to to the play, it might not actually be established with respect to the sound recordings and the underlying original copyright works in the music, mainly because these are not used to make a satirical point. They're used to put in the soundtrack just to avoid paying for music or avoid licensing or creating your own soundtrack. So in that case, then there's no real argument there that Audrey used those works to make a parody or satire. And it's not really clear, and I don't think that the exception would extend to those circumstances. So while she might win on any action brought by Beckett's heirs, she probably wouldn't win on an action brought by the people who own the copyright in the recorded music and the underlying Part 3 works. So then we have to go through remedies. First one is injunctive relief, relatively simple, and then damages or account of profits. Not much difficult to do there. The other bits that you might not pick up on if you read it too quickly and you're not really familiar with what you're looking for is there might be a moral right question here. So by taking Beckett's play and subjecting it, or taking the play and making it into a satire of refugee policy, there might be a question of whether or not Audrey has infringed the moral rights of Beckett. And the moral rights, the one here, there might be an attribution one, maybe. It's not clear whether she provides attribution, so yeah, maybe she doesn't provide attribution. And that would certainly breach the moral right of attribution unless it was reasonable in the circumstances not to do so. The other one that's a little bit more complicated is it a breach of the moral right of integrity? By presenting this particular play in a new context that makes a political point, is that something which the original author can object to? And you'd have to go through some of the authorities. Again, because this is relatively new, we don't have a lot of Australian authority. But you have to work through the tests. First, is it derogatory treatment? And which means we need to identify whether this is prejudicial to the author's honour or reputation. So we don't have a lot of authority, but is it something that is likely to be to harm the author? And is it something that is objectively likely to harm someone like Beckett to put on the play in this particular circumstance? I think that in this case, because it's quite clearly taken out of context, it's not a production of Beckett's play. People wouldn't necessarily think worse of Beckett, so it's unlikely to really hurt Beckett's reputation. Whether it would hurt his honour, you'd have to make some sort of argument. We don't really know whether honour just means subjective harm or whether there's a level of objectivity that's required. If there is a level of objectivity that's required, it's not really clear that this would really harm Beckett. The tricky part is that in France, Beckett actually was successful in suing, or Beckett's heirs were successful in suing under the moral right of integrity, I think in one of the European jurisdictions, where someone put on his play led by female leads. And that was something that his heirs said that Beckett would have been very upset about. I don't think that Australian law would necessarily go that far, but it's possible. Finally, if we do argue that it is a breach of the moral right of integrity, we have to consider whether or not it's reasonable to submit a play to derogatory treatment in order to create a political satire. And there's a bit of an argument to be made here. What's the use of having a parody and satire exception if we don't, if in practice it's always going to be a breach of the moral right of integrity? We don't exactly clear where that overlap is, but you'd have to make some sort of argument of whether or not this is reasonable in the circumstances. Then the final part, after we've come to some sort of conclusion about primary liability for Audrey against all of those copyright owners, we then need to look at Cine Speech's secondary liability. So Cine Speech here provides Audrey with the resources to actually make her film. It's a community arts center, provides equipment, provides equipment for hire and material that she can use, where she ended up conducting editing and post-processing on their computers. So are they likely to be liable for the act of their client? So we've got to look at the extent to which this is first thing we have to do is look at the section 101(1)(a) factors. As you'll see, 101(1)(a), and obviously 36(1)(a) for the Part 3 works. We need to look at the extent of the person's power to prevent, the nature of the relationship, and whether the person took any reasonable steps. So going through each of those. Power to prevent, I mean, is this like Morehouse, where giving someone access to photocopiers in a library leads, you would assume that they're probably likely to infringe copyright in some of the books if you don't do something? Really, it's not clear that Cine Speech has really done enough in this case to trigger liability, even under the Morehouse test. Following the IronNet case, it's pretty clear that they're too far removed. They don't have a real direct power to prevent infringement here. The nature of the relationship, it's a basic contractual relationship. It's not like Cine Speech benefits from the infringement, not like Cooper did, even though there is a suggestion on this infringement. So there is a suggestion here that Cine Speech adds a 15-second advertisement at the end of the completed film. So Cine Speech benefits from Audrey's work, but it's not clear that they specifically benefit from the infringement. So I'm going to say that that factor weighs against them as well. And then the final factor, reasonable steps. Really, what could Cine Speech have done? Would it be reasonable for Cine Speech to monitor everyone who uses their materials to check whether they're infringing copyright? It doesn't sound very reasonable. Maybe it would have been reasonable to put up some posters that say "Don't copy other people's music." Maybe that was the case. That was the argument in Morehouse. It's hard to tell, but I would tend to think that this sort of situation is a bit too far removed to trigger authorization liability. So that's it. That is a very quick run through of the question 2 in the 2012 exam. Remember that whenever we're looking at copyright, there are 5 basic steps that we go through. We check subsistence. Where are the different works and other subject matter that are protected by copyright? We check ownership, who owns these rights. We check infringement. This one takes time. We need to look at all of the different actions that might exist against the particular person that we're advising: direct, indirect, and authorization liability. Then we check our defenses and our remedies. 5 basic steps to get you through a copyright question, and then obviously check moral rights as well. Okay, so that's copyright in a brief nutshell. If you have any questions, please feel free to email me or come see me during my consultation hours. Good luck on the exam.